It's a pleasure to participate in the World Intellectual Property Forum, and I'd like to thank the organizers for inviting me and giving me an opportunity to share some views. I'm also happy to note that the forum this time is starting on 26th April when the World Intellectual Property Organization celebrates the World IP Day to discuss the role of IP rights in encouraging innovation and creativity. The theme this time is taking your ideas to the market, emphasizing how IP rights help SMEs build stronger and more competitive businesses. It was in the year 2000 that the member states of WIPO designated April 26th as World IP Day, marking the date on which the World Intellectual Property Convention came into force in 1970. Today, I thought I would speak on a topic which is rather current and critical, given that the world is facing a situation similar to one a few decades back, but has reacted very differently this time. Though I hasten to add that the earlier situation was not as serious as what we are facing today. If there is one issue which is keeping the planet totally engaged today, it is the COVID pandemic. And that is certainly not surprising given the magnitude of the problem. By mid-April, 136 million people had been affected around the globe, with almost 3 million dead. In the Hong Kong flu about 50 years back, about 1 million had died and 32 million through AIDS, but that was over a period of 40 years. Neither of these was as serious as this one, given the short period in which we've had such fatalities. All nations are battling the challenge through various measures, which in turn has wreaked havoc with the world economy, pushing the vulnerable sections of the population into poverty. Scientists and the finest minds of the world are working on vaccines to meet the challenge and produce enough doses to meet the requirements of the world population. While earlier it used to take about 10 to 20 years to develop and test vaccines, now in less than a year, several vaccines have already come into the market. But what is surprising is that there's very little talk about patent protection, apart from a few issues I will discuss at the end. Though, of course, there's not much of a debate, which was not so 25 years back. At that time, the WTO agreement had just been concluded and TRIPS had become a reality. The developed world was aggressively asserting its rights on patent protection through bilateral and multilateral routes. India faced two disputes at the WTO as we had defaulted on some TRIPS obligations. Of course, we both lost both and had to amend our laws. But the case which grabbed the world attention was in South Africa. In 1998, 39 pharmaceutical manufacturers sued the government to prevent the implementation of a law designed to facilitate access to AIDS drugs at low cost. The companies accused South Africa, which had the largest population of individuals living with HIV/AIDS in the world, of circumventing patent protection guaranteed by TRIPS. This act had been passed by President Nelson Mandela to promote more affordable medicines by A, using parallel importation, B, authorizing imports of generic versions through compulsory licenses, C, ensuring distribution of cheaper generic copies, and D, establishing a committee to control prices. At that time, the annual income of an average South African was $2,600, whereas the cost of curing AIDS was about $1,000 a month. While AIDS activists called for international protests against drug profiteering, the companies defended the court action on the grounds that parallel importation of drugs would undermine their ability to charge different prices in different parts of the world. Pharma convinced the US government to put pressure on South Africa by putting the country on the Special 301 watch list both in 1998 and 1999, and also by withdrawing GSP benefits. There was uproar in the global media, and a whole lot of activists stepped in to defend South Africa. At that time, the US presidential election was on, and Al Gore was contesting the election. He became a target of the activists. The aid activists, realizing that the 2000 presidential campaign made Gore particularly vulnerable to negative publicity, disrupted a number of his campaign events, ultimately forcing the US government to change its stance. After a series of negotiations in September 1999, the United States Trade Representative and the South African government announced a patch-up under which, one, the US government would no longer pressure South Africa, and two, South Africa promised to adhere to its obligations under TRIPS. Consequently, the pharma companies dropped their lawsuit in 2001. But the pressure was sustained. The African group put it on the agenda of the 4th Ministerial Conference of WTO held in Doha, Qatar in November 2001. At the end of the conference, the WTO member states adopted a declaration on TRIPS agreement and public health. The Doha Declaration affirmed that under the TRIPS agreement, a member state had the right to grant compulsory licenses and determine the grounds, had the right to determine what constitutes a national emergency, and was free to establish its own patent exhaustion regime. It also recognized that WTO member states with insufficient or no manufacturing capacities in the pharmaceutical sector could face difficulties in making effective use of compulsory licensing under TRIPS. This subsequently led to the Para 6 amendment at the WTO. Now, principally, there were three factors for the success of developing countries. Number one, they were united. Number two, the traditional views adopted by the United States and other Western countries was not easy to maintain after the 9/11 incident and anthrax scare. Both Canada and the United States said they would use compulsory licensing to deal with the then scarcity of Cipro. And lastly, a large number of AIDS activists and NGOs made sure that the issue received a great deal of publicity. And in the next decade, there were several other developments. The UK Commission on IPRs in 2002, UNCTAD 11 in 2004, the Second South Summit in 2005, the Government Accountability Office report of the US Congress in 2007, and the OECD report in 2007. All these commissions and all these reports principally emphasized the fact that IP rights had to be balanced with public interest. This ultimately led to the adoption of the WIPO development agenda, which itself was a long process of 4 years, which concluded that IP was not an end in itself, but a means of promoting public interest, innovation, and access to science and technology. And integrating the development dimension will strengthen credibility and encourage its acceptance as a tool for innovation, creativity, and development. What was the effect? Developed countries no longer take developing countries to a dispute on patent rights. Between 1996 and 2001, 16 out of the 24 IP disputes at the WTO were against developing countries. And as I mentioned, 2 of the first disputes were against India, were the United States and the European Union. The tagline on intellectual property now is striking a balance between protecting rights and upholding public interest. Now let's come back to the present day. In May 2020, the WHO officially launched the COVID-19 Technology Access Pool, a patent pooling initiative proposed by Costa Rica. The action was meant to encourage the licensing vaccines to the United States medicines patent pool and promote open innovation models through tech transfer supported by 36 countries. A month later, in June, the WHO issued the Solidarity Call to Action. Under this, an equitable global access to COVID-19 health technologies was meant to be achieved through pooling of knowledge, intellectual property, and data. WHO's efforts to promote global public health goods based on equity, strong science, open collaboration, and global solidarity has been bearing fruit. Separately, under the COVAX facility, 38 million doses of COVID vaccines have been delivered to about 100 countries around the globe. In October 2020, at the WTO, India and South Africa sought a waiver on certain provisions of the TRIPS agreement to speed up efforts to prevent, treat, and contain the pandemic. In the paper, they stressed that IPRs were hindering timely provisioning of affordable medicines, concern for countries with insufficient or no manufacturing capacity, and also talked about the difficulties using the flexibilities under the TRIPS agreement. The paper has been opposed by pharma companies and the industrialized countries. No final decision has been taken yet. But one does not expect the same kind of belligerence as the world is now more sensitive to such issues, though it is imperative to provide recompense to private companies which are sinking millions into research. Studies are made from time to time to assess the actual costs incurred by pharma companies in inventing a new drug and bringing it into the market. The costs incurred would include the preclinical stage to market approvals and at times also post-approval costs. In 2019, Deloitte estimated these costs at around $2 billion US. Even if one provides for the costs, which needs to be backed out for use of publicly available research data and tax breaks on R&D, it's very clear that the pharmaceutical companies have to be compensated for their expenses in order to continue providing them with an incentive to research on new drugs. However, at times, certain diseases assume a pandemic form, and it is obvious that some special dispensation has to be worked out to meet with the global challenge. This issue, as I said, was being debated at the WTO, and several options were being considered. Alternatives, such as appropriation of the patent for government use and issue of compulsory licenses, would not really solve the problem, as firstly, it would have very limited application, and more importantly, definitely not elicit any cooperation from the patentee. Certain countries have been working on the option of buying out the IP rights of the company by compensating them adequately and then making the product available in the market for wider use. However, what needs to be noted is that even though these discussions have been going on, intellectual property issues have not assumed the kind of importance and significance as they had in the AIDS case about 2 decades back. In a way, this is a healthy development as inventors, manufacturers, and government authorities are aware of the fact that the confrontation is not going to help anyone and that there's a need to devise a viable understanding soon so that neither party suffers. Hopefully, we will have solutions soon. I'd like to thank the organizers again for inviting me to this forum, and I hope we are able to take these discussions forward in order to arrive at the right kind of solutions for all countries and people around the globe. Thank you very much for your attention.